Okay, great. Hi, everyone. Welcome. Thanks so much for joining us. This is the panel on background checks, crime-free housing ordinances, and fair housing. I think more people are joining, but we'll just go ahead and get started now. My name is Mariel Block. I'm a senior counsel with the Department of Fair Employment and Housing in the Legislative and Regulatory Unit. And I'm joined here by two wonderful speakers. We have Marcos Segura, who's a staff attorney with the National Housing Law Project. And the National Housing Law Project is a national nonprofit legal aid support center and federal policy advocacy agency that advocates on behalf of low-income tenants. And we also have Nathaniel Hill here, who is the Program Compliance Branch Chief of the Los Angeles FHEO office with the U.S. Department of Housing and Urban Development, Office of Fair Housing and Equal Opportunity. So Marcos is going to be going over typical features of nuisance and crime-free housing ordinances and some potential liability under state and federal fair housing laws. And Nathaniel is going to be going over the federal side. He's going to be covering HUD guidance, some new obligations under the 2022 Violence Against Women Act reauthorization. And he's also going to talk about a case study that he's been involved in a federal enforcement action for a jurisdiction with a nuisance and crime-free housing ordinance. At the end of the session, there'll be some time for Q&A. You can feel free to use the chat feature, the Q&A feature for your questions. We'll do our best to answer. But I do need to preface with the fact that we cannot provide legal advice here today. Next slide, please. Another disclaimer that this presentation doesn't establish any substantive or policy rights or constitute legal advice. And the views expressed by our presenters here are not necessarily those of DFEH. Next slide, please. We are a bit on the early side, but I think we can do this poll anyways. Who is in the room? Please choose what best represents your organization. Just going to give it a few minutes because I know people are also still joining. Okay. So it looks like we're about 44% housing developers, 19% property managers, 6% local municipalities, 6% state agency, 19% service providers, and 6% attorneys. Welcome, everyone. Okay, next slide, please. Okay, one more quick poll. How much experience and knowledge do you have regarding nuisance and crime-free housing ordinances and fair housing laws? Okay, looks like about 80% of you have a little bit of knowledge, 13% have no experience or knowledge, and 7% have a lot of experience and knowledge. Be really interested to hear from those folks as well. Okay. Next slide. A little bit about the mission of DFEH. The Department of Fair Employment and Housing is California's civil rights agency, and we protect the people of California from unlawful discrimination in employment, housing, businesses, and state-funded programs, and also from bias-motivated violence and human trafficking. Next slide, please. DFEH has a number of functions. We engage in public outreach and training, provide technical assistance to employers, business establishments, and housing providers regarding their responsibilities under the law. DFEH investigates discrimination complaints and also can facilitate mediation in our dispute resolution division, as well as file affirmative enforcement actions in court. And we'll talk a little bit more about some DFEH enforcement activities at the end of this presentation, but for now, I'm going to turn it over to Marcos to introduce you all to nuisance and crime-free ordinances. Next slide, please.
Thanks, Muriel. So as Muriel mentioned, I'm going to provide an overview of rental housing crime-free programs and nuisance ordinances with a particular focus on California. Next slide. So rental housing crime-free programs and nuisance ordinances are often touted by local government officials as a tool to fight crime, blight, and nuisance behavior. In reality, these laws are designed to exclude certain racial and ethnic minorities from the local jurisdiction. A closer look at these laws actually bears this out. A 2020 analysis by the Los Angeles Times showed that many California jurisdictions that passed some variation of a crime-free program or nuisance ordinance did so in response to a sharp increase in their Black and/or Latinx population. And in many of these jurisdictions, crime was either stable or on the decline. Next slide, please. There are over 2,000 municipalities across the country that have some variation of a crime-free program or nuisance ordinance. 147 of them are in California. Because of the racial animus behind these laws, they are disproportionately enforced against Black and Latinx individuals. They also harm survivors and individuals with disabilities, since these groups tend to have greater contact with the police. The disproportionate impact of these laws on these groups could lead to local government liability under the Federal Fair Housing Act and under California's Fair Employment and Housing Act, or FEHA. These laws may also be inconsistent with a jurisdiction's obligation to affirmatively further fair housing, which I think our next speaker is going to talk about in a little bit more detail. Next slide, please. Here's an excerpt from the article that I reference, drawing the connection between demographic change and the enactment of crime-free programs and nuisance ordinances. It shows that 85% of the jurisdictions with the highest increase in the Black population pass some form of a crime-free program or nuisance ordinance, which supports the argument that these laws are being enforced in response to demographic change and not as a way to fight crime. Next slide, please. So what is a crime-free program or nuisance ordinance? A nuisance ordinance is a law or policy that applies to rental housing that penalizes landlords and tenants for activity that occurs on the property and sometimes off the property. Crime-free programs do the exact same thing, except that they're typically voluntary. However, they incentivize owner participation in a variety of ways. Some jurisdictions have both a crime-free program and a nuisance ordinance. Next slide, please. So activities prohibited by these local policies might include calls to the police or 911 emergency services, virtually any criminal activity, including minor nonviolent offenses, and even when committed away from the property, congregating, loitering, unruly gatherings, domestic disturbances, noise, littering, and failing to cut a lawn or otherwise maintain the property. Next slide, please. Penalties imposed by these local measures might include the eviction of tenants, imprisonment, daily fines, reimbursement for the cost of city abatement, and in the most extreme cases, it could include condemnation of an entire apartment complex. Next slide, please. These laws sometimes require owners to conduct a criminal background check of every single rental housing applicant and of every single existing tenant when they seek to renew their lease. Sometimes the law will either require or encourage local law enforcement to conduct the required criminal background check. Sometimes they require prospective tenants to obtain an occupancy permit in order to rent a unit in the jurisdiction. The cost of these permits is sometimes cost prohibitive for low-income individuals who tend to be Black and Latinx. Some of these laws authorize jurisdictions to maintain a tenant registry, which often identifies tenants as either bad or criminal. Some laws require landlords to register as rental property owners. And some laws require landlords to use crime-free lease addendums, which have the effect of fast-tracking evictions. Next slide, please. These local laws also use broad, vague, and or subjective definitions of criminal activity and nuisance behavior. They require or encourage a tenant to be evicted for alleged criminal activity, even without a conviction or even for activity that didn't happen on the property. They require or encourage a landlord to evict an entire household, not just a person accused of a crime or nuisance behavior. They define nuisance to include emergency calls and even mere contact with the police. And they equate minor infractions with serious infractions in that they both require a tenant's eviction. Next slide, please. So now let's look at some specific examples. The city of Fresno has what I consider to be a pretty standard nuisance ordinance. That ordinance defines nuisance in ambiguous terms like unnecessary or unusual noise, causing annoyance or discomfort to an ordinary person of normal sensitivities, habitually engaging in prohibited conduct, and the disruption of the character of the community. The ordinance also punishes residents for frequent police calls to the adjacent area, despite the fact that tenants typically don't have control over what happens around their apartment complex. Responsible parties include all occupants, not just the person engaged in the alleged prohibited conduct. And under threat of heavy fines, owners have 5 days from when the city issues a notice of violation to abate an alleged nuisance, and it actually suggests eviction as a solution. Next slide, please. The next slide after this one, sorry, I skipped. The city of Fremont administers a crime-free housing program. Like other crime-free housing programs, it is completely voluntary. However, the city publicly lists quote unquote fully certified properties, and it characterizes these properties as crime-free and safe. So if your property is not on this list, the clear implication is that your apartment complex is not crime-free and it's not safe, which effectively forces the property owner to participate in the city's program. Next slide, please. To be a fully certified property, an owner must complete all 3 phases of the city's program. This includes training for property managers on applicant screening, drug and crime recognition, the eviction process, and how to work with police and code enforcement. Owners must also use the city's suggested quote unquote lease addendum, which prohibits criminal activity both on and off the property. To be fair to the city, it also provides training on fair housing and crisis resolution, which might evict an eviction in some situations. Next slide, please. California has what are known as unlawful detainer pilot programs. These programs involve nuisance ordinances just like the ones I described, except that they authorize the city attorney to directly evict tenants. Participating cities are Los Angeles, Long Beach, Oakland, and Sacramento. Next slide, please. Some jurisdictions don't have a traditional crime-free program or nuisance ordinance, but they still impose crime-free and anti-nuisance policies through other city or county programs. For example, grants for the development and preservation of affordable housing, and through other zoning and land use laws. For example, a jurisdiction in Orange County required developers making use of its density bonus law to use a crime-free addendum or lease for the affordable units that it developed. Next slide. So local government officials should keep an eye out for this type of obscure policy, since it presents the same issues of discrimination and it carries the same risk of local government liability, which I'm going to talk about next. Next slide, please. One source of local government liability is the Federal Fair Housing Act, which prohibits discrimination in the leasing or sale of a dwelling based on a person's protected class status. And discrimination includes government policies that have the effect of denying a dwelling to members of a protected class. The Fair Housing Act applies to property owners, property management companies, banking institutions, and local government agencies. And the act prohibits housing discrimination on the basis of a person's race, color, religion, sex, familial status, or national origin. Next slide, please. California has the Fair Employment and Housing Act, or FEHA, which is the state's analog to the Federal Fair Housing Act. It also prohibits government policies that have the effect of denying a dwelling to members of a protected class. However, FEHA's protections are much broader. It not only prohibits discrimination based on race, color, religion, sex, familial status, or national origin. It also prohibits discrimination based on gender, gender identity, gender expression, sexual orientation, source of income, and that includes Section 8 rent subsidies, disability, genetic information, and a person's veteran or military status. Next slide, please. FEHA regulations prohibit government policies that require action against a person based on broad definitions of nuisance or criminal activity, including the initiation of eviction proceedings. They also prohibit arrests not leading to a conviction and juvenile criminal records from being considered during the application screening process. Next slide, please. FEHA regulations also limit consideration of a person's criminal record to convictions that relate to the safety of other residents, employees, or the applicant's ability to meet the terms of their lease. And even in those situations, the applicant has an opportunity to present mitigating information, such as the amount of time that has passed since the conviction, whether the history is accurate, and evidence of rehabilitation. Next slide, please. General state law also protects DV survivors and individuals facing an emergency situation from being evicted for trying to access emergency services. Despite all of these protections that I mentioned, laws and policies that violate these protections remain in the books and are still being enforced either by a local government or a private landlord pursuant to crime-free lease provisions required under a local crime-free program or nuisance ordinance. Next slide, please.
Excellent. Thank you, Marcos. I appreciate that background, that wealth of information that you provided. Hopefully my presentation will dovetail with a lot of what you said and sort of help also tie some of these things together. Good afternoon to everyone out in the audience. I thank you all for your time and for your attention to this very important topic. Of course, I would much prefer that we were all there together, especially selfishly. This is now my third consecutive year where every Fair Housing Month event I'm participating in is done entirely over the computer. And though I think my Zoom game has appreciated over those 3 years, I'm getting tired of the inside of my apartment and the lack of human interaction. And I really find that a lot of these seminars do benefit from that face-to-face time, the ability to sort of riff off questions and engage in interactive dialogue on this. I'm sure you're all tired of the online stuff as well, but I appreciate that you are all here and that you're all willing to engage with me, albeit behind a computer screen. As mentioned, I hope my presentation builds off and complements a lot of what Marcos said. though I realize probably my section will be somewhat of a fast-paced overview of topics that we in all likelihood could spend hours on. So I know I had a brief introduction at the start of it, but just to reintroduce myself, my name is Nathaniel Hill, and I am the Program Compliance Branch Chief in HUD's Office of Fair Housing and Equal Opportunity in our Los Angeles office. For those who aren't familiar with HUD's structure, at least the structure of the Office of Fair Housing and Equal Opportunity, my branch, the Program Compliance Branch, works directly with recipients of federal funding, such as housing authorities, multifamily housing providers, local governments like cities, states, counties, and we work with them to achieve and remain in compliance with the slate of federal civil rights laws and statutes that we have the authority to enforce. And one of the ways that we do that is through compliance reviews, which is what I'll end my presentation on today, going through a recent compliance review that my office undertook. So before getting substance of my presentation, I did just want to quickly extend a couple of thanks. First of all, thank you to my fellow presenters on the panel and to those who helped organize this panel. And thank you to Housing California for organizing this great event and for the invitation to participate. And finally, thank you to everyone out in the audience. Again, I appreciate your time, I appreciate your attention, and I appreciate your engagement. I think it's through opportunities and collaborations like these that we all achieve the goals that we're in this housing world together to achieve. So, you have the next slide, please. Awesome, thank you. So I think it's important that we sort of start off with some backgrounds, and most importantly, getting a definition of disparate impact on the table, because the disparate impact, the concept of disparate impact essentially forms the backbone of a lot of what Marco's covered and a lot of what I'm going to cover this afternoon. So I just wanted to start off with ensuring that we all understand what we talk about when we bring up this concept of disparate impact. So generally speaking, we're talking about a policy or a practice, while neutral on its face, that has a disproportionate impact on one or more protected class groups, even when that policy is applied to everyone. So we see here on this slide, this is the definition from the original disparate impact final rule, which talks about that concept of policies and practices that have this discriminatory effect against people based on membership in a protected class, or that can perpetuate various existing patterns that we see, whether patterns of concentration or segregation or exclusion, things like that. Next slide, please. Great, thank you. So building off that concept of disparate impact, in 2016, HUD released this guidance on the use of criminal records by housing providers. And in a sense, this 2016 guidance was the culmination of a multi-year effort in which the department had begun really trying to examine the relationship between secure housing and recidivism, recognizing that access to safe and secure and affordable housing was vital to ensuring successful reentry into society. HUD saw that the barriers confronted by many people with criminal records in accessing public and federally subsidized housing required the department to take steps to address sort of these collateral consequences that individuals were facing in their search to obtain and remain in housing. So the first steps that HUD took in this process dealt specifically with the public and federally subsidized housing. It was a series of notices that dealt with keeping people in and preventing eviction from public housing programs, and what types of criminal records could be utilized, what type of criminal history could be considered in evaluating applicants for these assisted housing programs. But this 2016 guidance built off that and recognized that the view HUD was taking until that time was narrowly focused on that specific subset of housing, the assisted housing subset. And so this 26 guidance recognized that the department can go further and that the department needed to consider the racial and ethnic disparities in the criminal justice system and how those disparities could have an associated disproportionate impact on various protected class groups and their ability to secure housing, whether that housing was subsidized or on the open market. So as this slide suggests, or specifically states, having a criminal record in and of itself obviously is not a protected class. It's not something that's explicitly covered by the Federal Fair Housing Act. But what the guidance points out is that the ways in which a housing provider factors in criminal records or criminal background into housing decisions can have a disparate impact on various protected class groups. And we'll sort of, I know I'm speaking very generally about protected class groups, but as we start to look at some data, we'll see what protected class groups predominantly we're talking about when we look at the disparate impact of criminal records policies. So when a policy does have a disparate impact, unless the housing provider is able to demonstrate that that policy serves a substantial, legitimate, non-discriminatory interest, that policy is likely a violation of the Federal Fair Housing Act, which essentially applies to all housing providers. And I realize that right now I'm focusing exclusively on housing providers. And I know someone in the beginning survey mentioned that they were here from a local government, but while this 2016 guidance does focus on criminal records guidance, all this also applies if we think about the framework of crime-free housing ordinances and nuisance ordinances. This idea of having a policy, albeit one that may be neutral on its face and that's being equally applied to everyone, but that can have this disparate impact against various protected class groups. So while I may be speaking about housing providers, please keep in mind that this does apply more across the board than just that one group. So next slide, please. Great, thank you. So how do we get to how do we get from our definition of disparate impact to this idea that criminal records policies, the use of criminal backgrounds in making a housing decision has a disparate impact? So first, let's start with just trying to establish a scope. And this is probably a very superficial scope at best, but just trying to establish a scope of what our criminal justice system looks like. So as many as 100 million US adults, which is just shy of a third of our population, have a criminal record of some sort. We have a prison population of 2.2 million people, and I think that was as of 2015. So it may have shrunk during COVID with some of the releases. It may have expanded since then. But at least at that time, it was the largest prison population in the world. And though the United States total population accounted for about 5% of the world's population, we had about a quarter of the world's prison population. And that since 2004, on average, 650,000 people are released annually from federal and state prisons, and about 95% of people currently imprisoned will be released at some point. So that's giving us just sort of that broad sketch outline of interactions with the criminal justice system. But then when we take into consideration the fact that African Americans and Hispanics are arrested, convicted, incarcerated, and essentially interact with the criminal justice system at rates disproportionate to their share of the general population, you can really start to see how criminal records policies and crime-free housing policies can have a disparate impact. Next slide, please. So let's look specifically at some data. So admittedly, this data is a couple of years old. I apologize for not having updated it before today. But so what this data is showing us is that racial and ethnic minorities face disproportionately high rates of arrest and incarceration. So for instance, in 2013, African Americans were arrested at a rate more than double their proportion of the general population. In 2014, African Americans comprised approximately 36% of the total prison population in the US, but only about 12% of the country's total population. So in other words, African Americans were incarcerated at a rate nearly 3 times their proportion of the general population. Similarly, Hispanics were incarcerated at a rate disproportionate to their share of the general population, with Hispanic individuals comprising approximately 22% of the prison population, but only about 17% of the total US population. Whereas, as the last set of numbers shows, in contrast, non-Hispanic whites comprise approximately 62% of the total population, but only about 34% of the prison population. So overall, while these numbers have shifted somewhat over the recent years, we see that across all age groups, the imprisonment rate for African-American males is almost 6 times greater than for white males. And for Hispanic males, it is over twice that for non-Hispanic white males. Next slide, please. Okay, so we see sort of how that data can inform how these various policies might have a disparate impact. So there's a policy on the books. How do we evaluate whether or not that policy actually has a disparate impact? So our disparate impact rule put forward this concept of a 3-part burden shifting test. It's a little nuanced, but we'll sort of walk through these 3 steps and see how it allows us to do an analysis. And this, again, is something that we would use for essentially any disparate impact claim, but obviously the crime-free housing ones, some nuisance ordinance ones, and these criminal background ones. But in this first step, in step 1, the plaintiff, the person bringing this complaint, must prove that the criminal history policy has a discriminatory effect. They must be able to assert that this policy has a disparate impact on a protected class group. So like we just walked through, they can cite national statistics that can help provide grounds to HUD to investigate complaints challenging these criminal history policies. They can identify data that demonstrates that racial and ethnic minorities face disproportionate high rates of arrest or incarceration. Though, they can cite applicant data, tenant files, census data, sort of more localized criminal justice data, really any data source that will be relevant in demonstrating and helping determine what role this policy was potentially having and how that policy was having this disparate impact. So in that second step, so the plaintiff steps forward, says, this policy has disparate impact. Here's my data points that demonstrate that disparate impact. That burden is now shifted over to the defendant, the housing provider, the jurisdiction with the challenged ordinance on the books, whatever it may be. And in that second step, the housing provider or the jurisdiction has to prove that this policy that they have is in fact justified. So they can't cite some hypothetical or speculative defense. They must be able to provide evidence that demonstrates that the housing provider has this substantial, legitimate, non-discriminatory interest that supports the challenge policy, and that the challenge policy actually achieves that interest. So when we're talking about these criminal records policies, and again, this applies to the crime-free housing stuff, any sort of policy that fails to take into account things like the nature and severity of an individual's conviction is unlikely to pass that standard. It's unlikely to demonstrate how sort of this blanket conviction ban or blanket policy is going to satisfy that substantial, legitimate, non-discriminatory interest. Similarly, like a policy that doesn't consider the amount of time that has passed since the criminal conduct occurred. And that's something that a lot of research has really substantiated, where we see that as time passes from the original criminal conduct, the likelihood that one will reoffend decreases over time. So it's important that these policies have that time element in their consideration, because again, otherwise it becomes difficult to deal with that burden of demonstrating that your time-blind policy achieves your substantial, legitimate, non-discriminatory interest. So let's say that the housing provider does that. They're able to demonstrate that three-part thing and that the policy serves that legitimate interest. Then the burden would shift back to the original defendant, who would then have the obligation to be able to demonstrate that there is, in fact, another practice that would serve that same interest, but in a less discriminatory manner. So that's sort of that three-step burden shifting process that we go through when evaluating these disparate impact claims. Next slide, please. So just sort of want to dive in a little deeper on a couple of things I touched on briefly when talking about that three-part burden shifting test and that concept of the housing provider establishing their interest. A couple of things which are not going to pass muster are things like policies that exclude people because of arrest. So before HUD had issued this 2016 guidance, there was a previous guidance directed specifically at public housing agencies that clarified that arrest records cannot be the basis for denying admission or terminating assistance or evicting tenants from public housing or other types of federally assisted housing. This guidance identified how the Supreme Court in several cases had recognized that the mere fact that someone had been arrested does very little. It provides almost no value in showing that that person has engaged in any misconduct. An arrest shows nothing more than the fact that someone probably suspected that person was engaged in an offense. But outside of that, it doesn't constitute proof of any past unlawful conduct. And arrest records are often incomplete. They don't necessarily indicate whether that individual was prosecuted, or if they were prosecuted, if they were convicted or acquitted. So the fact of an arrest in and of itself is not a reliable basis upon which to assess the potential risk that a person might pose to resident safety or to property safety. And again, while this is focused mostly on that criminal record stuff, as Marcos identified when he was talking about the crime-free housing ordinances, a lot of them have those crime-free lease addendum, which will include language, very ambiguous language about engaging in criminal activity on or near the premises, and have very loose and expansive definitions of what criminal activity is and what constitutes proof of criminal activity. So we will see crime-free housing ordinances which specifically accept arrest as proof of engaging in criminal activity. And then depending on the specifics of that crime-free housing program can result in a range of consequences, which Marcos outlined. It could result in eviction from housing. It could result in, fines levied against landlords, things like that. So this concept of basing any sort of housing decision on an arrest record is one that is not going to satisfy HUD's analysis of a crime-free housing program, a nuisance ordinance, or criminal background policy when a complaint has been made about that policy having a disparate impact. Next slide, please. So moving from arrests to convictions, I think we're all willing to agree that a conviction would generally serve as sufficient evidence to prove that an individual has engaged in criminal conduct. However, a housing provider who had a policy of excluding all persons with prior convictions must still be able to prove that that blanket policy is necessary to achieve that substantial, legitimate, non-discriminatory interest. And that's going to be a hard barrier or hard thing to cross. But even in instances where a housing provider has a more tailored policy, let's say they're excluding individuals with only certain types of convictions, there still is that obligation to be able to demonstrate that those convictions that they're excluding are actually serving that substantial, legitimate, non-discriminatory purpose. Now, of course, if we're focusing on the federally assisted housing for a minute, there are the convictions that require exclusion from the program or termination of assistance. But we're just talking about, generally speaking, sort of if a housing provider has that more tailored conviction policy, then they must be able to demonstrate that those convictions that they're excluding do fulfill that interest. Next slide, please. So it's always important to keep in mind that we're all most likely recognize that ensuring residents and employee safety and protecting property are fundamental. But while keeping in mind that those things are fundamental, it's important that any criminal record policy clearly establishes the connection between protecting property and preserving resident employee safety and whatever criminal history they're prohibiting. So like bald assertions based on generalizations or stereotypes that any individual with a criminal record poses a greater threat to resident safety or to property is not going to be sufficient. You need to have that more tailored approach that demonstrates that this type of conduct is reasonably connected to legitimate concerns about resident safety or protection of property. Next slide, please. All right, so we've spoken exclusively about that disparate impact concept and how these policies can present a disparate impact. But it's important that we keep in mind that these policies can be used to discriminate in a different way, which is the disparate treatment or the intentional discrimination. So this can be true for criminal background policies, but it can also be true for the crime-free housing policies and the nuisance ordinances. And these types of things can be discriminatory when they're used to treat people differently, explicitly because of their membership in a protected class. So a few years ago, a national civil rights organization in Washington, DC had conducted a rental testing survey of rental opportunities across the District of Columbia. And they found that when they had one tester who was a white woman with a criminal history and a second tester who was a Black woman with the same criminal history approach rental properties to explore housing opportunities, even though they had the same criminal history, the white woman was treated more favorably, more frequently than the Black woman. So again, now we're not dealing with that disparate impact of the policy. Now we're dealing with, here's this policy and I'm intentionally applying it more rigorously to one person, or I'm not applying it to another person. And this is something that we can see a lot and a lot of studies have backed up with the application and enforcement of nuisance ordinances. I know Matthew Desmond has done a series of studies about this and has demonstrated how nuisance ordinances in cities like Milwaukee can be disproportionately enforced against Black households or other households of color, and especially when we're dealing with issues of domestic violence, then we're seeing that there is a lot of this disparate treatment in the enforcement of at what points does calls for emergency service become considered a nuisance type thing. So again, it's important to realize that when we're dealing with all these types of policies, we can be looking at the disparate impact that they cause, but also the disparate treatment that their enforcement can cause. Next slide, please. Thank you.
Apologies, we seem to have lost power briefly here.
Oh no. I was about to blame Comcast. That's my normal go-to villain for things. All right, so I've been trying to allude back to, oh no, I think we're in the next slide if possible. There we go, thank you. Been trying to allude back to how all the things I'm saying also apply to the crime-free ordinances and the nuisance ordinances. But hopefully now that we've sort of walked through disparate impact and walked through that 2016 guidance that dives deeper into how the criminal background policies can have this disparate impact. When we think back through all the things that Marcos talked to us about, we can really start to see how these other types of ordinances, these nuisance ordinances and these crime-free housing ordinances can have these disparate impacts as well. So these policies that, as mentioned, forbid criminal activity on or near the premises, or these ordinances that set really broad definitions for what constitutes a nuisance and then set up a series of escalating penalties for households that are deemed for having perpetuated those nuisances. Depending on how those ordinances are written and enforced, they can have this disparate impact against these protected class groups. And next slide, please. So I know Marcos used some of the same stats as I did. And I know it seems like we're just copying each other, but I wanted to reiterate some of these numbers because I think it's really important to keep in mind how prevalent these ordinances are becoming. So the National Low Income Housing Coalition found over 2,000 municipalities nationwide have some form of nuisance ordinance. And that's not to say that all nuisance ordinances are bad. There's understandable reasons why certain types of nuisance ordinances exist, but the growth of these more pernicious types of ordinances is something that is on HUD's radar and something that we all need to keep in mind. So look at this 2019 study by Temple University. So they just studied the 40 most populous cities in the US, and they found that 37 of those cities had a nuisance ordinance. Of those 37, 25 of them required eviction as a response to the nuisance. And 5 of those 37 cities classified calls for emergency services, such as law enforcement, as a nuisance. Next slide, please. And then for the crime-free housing ordinances, the International Crime-Free Association's own website says that 2,000 cities across 48 states, the 5 Canadian provinces, and a few other countries have crime-free housing ordinances. And my final slide with these prevalence numbers. The same LA Times article Marcos referred to, we're talking about 147 cities and counties in California alone have crime-free housing laws on the book or have some type of crime-free program on the book. So that's talking about more than a fourth of all the local governments in the state. And again, I know Marco's hammered this point home, but of the 20 California cities with the largest increase in Black residents since 1990, 85 of them have approved crime-free housing policies. Next slide, please. All right. So with the time I have left, I wanted to highlight as a case study a recent compliance review my office conducted of the city of Hemet's crime-free and nuisance housing ordinances. So I'll get to why this picture is up for a second. This is an article from The Atlantic, but just to give some general context. So Hemet is a city of just over 80,000 people in Riverside County in Southern California, approximately 90 miles from Los Angeles. And as this Atlantic article gets at, like many cities, Hemet experienced substantial economic and demographic changes following the housing market collapse and recession in the 2000s. So between 2005 and 2015, the poverty rate in Hemet jumped from 13% to 20%. And in that same time period, almost 5% of businesses in the city closed. Housing prices and rents both dropped precipitously, and the city has yet to fully recover. Now, these economic changes paralleled significant demographic changes in the city. So during that time frame, the city's white, non-Hispanic population declined from 70% in 2000 to less than 52% in 2010, while the share of all minority groups, but particularly Hispanic residents, grew. So from 2000 to 2010, Hispanic residents accounted for more than 70% of the total increase in Hemet's population. Next slide, please. So as these quotes from this Atlantic article show, and from a lot of the public meetings that were out around this time, there was a lot of connection being drawn between the economic and demographic changes in the city and a perceived increase in crime. Next slide, please. So in response to these changes and the correlated perception of an increase in crime, the city responded with a comprehensive legislative package, which was entitled Restoring Our Community, or ROCKS. So ROCKS was cited specifically by the mayor at the time as something that was being implemented to, quote, address the influx of undesirable residents. And the cornerstone of this program was, quote, to make it harder for derelict landlords to rent to undesirable tenants. So when considering this ROCKS strategy, the mayor at the time identified many problems that the city needed to address, including that the city had, quote, attracted many lower income people. And again, that these landlords were attracting, quote, undesirables. When first considering this strategy, the city played a video at a city council meeting that was summing up the feelings of the city council when it compared Hemet to a post-Katrina aftermath. At the same meeting, though the sheriff noted that in fact violent crime was trending down, he noted that there was a perception of crime and that it was important that that perception of crime be addressed. The sheriff further said that there was, quote, an abundance of affordable housing, and this is a problem, and that there's an abundance of social services, and that is a problem. So the mayor said, ROCKS is going to lay the foundation or how we control the type of citizen that we want to come in and contribute to our community. So in 2012, as one of the first prongs of this multi-pronged ROCS approach, the city passed this ordinance, which is up on the screen, this Abatement of Chronic Nuisance Properties Ordinance. So this ordinance made it unlawful for property owners to allow any property under their control, whether owned, leased, or rented, to generate or be the subject of 5 or more calls for law enforcement or code enforcement for any nuisance activity during any 12-month period. There was no exception in the law for victims of domestic violence, victims of other crime or abuse, or persons with disability. Property owners were faced with a series of cascading consequences for exceeding that 5-call limit, which included fines, liens, revocation of the ability to rent their property in the city, jail time, and an order that the property be immediately vacated. The ordinance defined nuisance activity incredibly broad. Things like disturbing the peace, unnecessary noise, loitering, consuming alcohol in the front yard setback, or anything that was deemed injurious to health, indecent, or offensive to the senses, so as to interfere with the comfortable enjoyment of property. So again, we have Marco's touch on this, but this concept of defining nuisance so broadly that you're capturing up a lot of behaviors into it. Now, proof of nuisance activity did not require conviction, but could be satisfied with something as simple as a call to 911 from which an incident report was generated. Property owners pushed back on this at some city council meetings, and they raised their concerns that the ordinance could be punishing owners for calling 911 to report legitimate illegal activity that was occurring, let's say an illegal trespass. And the sheriff tried to quell those concerns by saying that there would be discretion that was applied, but that discretion can be problematic when we think back to the concept of the disparate treatment and how we're potentially selectively enforcing an ordinance and its consequences. So in addition to these concerns about the lack of protection for victims of domestic violence or persons with disabilities, this type of system effectively allows for the weaponization of 911 calls. One neighbor can target another neighbor with calls for service with the aim of amassing 5 or more calls to trigger this nuisance ordinance. So next slide, please. So we have their nuisance ordinance in place. Then in 2013, the next prong of the ROCS strategy is unveiled, and it's the Rental Registration and Crime-Free Rental Housing Program. So this ordinance placed mandatory registration requirements on all rental property owners as a condition of exercising the privilege of renting or leasing properties. All property owners had to participate in crime-free activities, which included certifying that they will evict tenants at properties that received any citation. So they had agreed to a series of crime-free certifications. They had to consent to crime-free inspections. They were required to use crime-free lease addendum. And that addendum, as Marco's pointed out, was the type of thing that said that tenants or their guests or anyone affiliated with the tenant would agree to live a crime-free lifestyle and not engage in this very ambiguously defined criminal activity on or off the premises without ever defining exactly how far off the premises can be. So again, just like defining nuisance very broadly, this crime-free ordinance defines criminal activity and location of criminal activity incredibly broadly. So the crime-free lease addendum that they were using for this program stated that the violation of any of those provisions, any of the engaging in criminal activity things, would result in a material and irreparable violation of the lease and would be good cause for the immediate termination of tenancy. And that a single violation would be good cause. And proof of violation, like with the nuisance ordinance, did not require criminal conviction, but could be met by an undefined preponderance of the evidence standard. So now let's go back to that criminal records guidance that I walked us through. So when we think back to the disparities in the frequency of interactions between the justice system and various protected class groups, you can see how policies like these would raise concerns that they would have a disparate impact against these same groups, which would be potentially exacerbated by these broad and ambiguous definitions and this very low threshold for proof. Next slide, please. So in 2020, my office initiated a compliance review of the city's rental registration and crime-free and nuisance ordinances under Title VI of the Civil Rights Act of 1964, which is one of the civil rights laws that my office enforces. We conducted this review under Title VI because the city of Hemet is the recipient of federal funding, but more specifically, they were using those federal funds to operate these programs. So we conducted our review under this law, though, as was pointed out during Marcus's presentation, these policies do also raise Fair Housing Act concerns when we're talking about the specific disparate impact, but also the affirmatively furthering fair housing concerns. But this review itself was just under the Title VI. So based on sort of the context surrounding the passage of the ordinances, which I just walked through, the economic and demographic changes, the perception of crime, and a lot of other public record research that we conducted, our office was concerned that these ordinances were potentially enacted for discriminatory reasons, and that in their application and enforcement, they were resulting in potentially discriminatory or disparate treatment. So we walked through some of the reasons why my office believed there was these ordinances would have been or were enacted for discriminatory reasons. So we saw those demographic changes. And at the time these ordinances were passed, not only were those demographic changes, but in the city itself, minority residents were significantly more likely to be renters than white residents were. And so when you think about the crime-free program, that's not a program that's applied to both owner-occupied and renter-occupied properties. The nuisance ordinance was, but the crime-free housing, the rental registration crime-free housing was only being applied to renter-occupied properties, where those properties are disproportionately housing people of color. And here's an ordinance that, when enacted, is going to disproportionately impact those same households. You see where we're concerned with the potential that this ordinance is being enacted for reasons. So another thing that concerned us was our preliminary investigation found that it did not appear that either of these ordinances consulted or relied upon any actual evidence that rental properties had more code violations, more nuisance violations, more 911 calls, or even more crimes than owner-occupied housing, or that renter-occupied housing posed any sort of disproportional threat to the neighborhood. In fact, in contrast to this assertion that these renter-occupied properties pose this disproportionate burden on the city, in some of the city's other public documents, they identified that some owner-occupied properties were grappling with really significant and severe maintenance problems. the city did not provide evidentiary justification for any of these assertions about the alleged burden that rental properties posed. And sort of the language that I highlighted earlier, the frequency of the undesirable epithet against tenants and the shifting demographics, really started to reinforce those concerns that these policies were being put in place to address demographic shifts and to assert some type of control over determining the demographics of the city moving forward. So, following our compliance review, we presented our preliminary findings to the city, and the city worked with us to reach a voluntary compliance agreement. This voluntary compliance agreement included a range of things, but most importantly is, as this slide alludes to, the repeal of both the nuisance ordinance and the rental registration crime-free ordinance, and the voluntary compliance agreement established a program that provides financial assistance to property owners who rent to low or moderate income households to proactively address and remediate potential code enforcement violations and otherwise improve housing conditions, the types of things that at least the nuisance ordinance was purported to be put in place to address. And next slide, please. So before ceding the stage, I did want to touch on one quick thing about the recent reauthorization of violence against women, or VAWA. So while HUD has not issued any actual guidance on this, because the president just signed this, I think it was March 16th. So we're presumably my headquarters is still working on fashioning guidance around this. But what really stuck out to me in my initial reads of the reauthorization was this highlighted passage. It was, well, this whole section, but especially this highlighted package. So here we're talking about just the jurisdictions that receive assistance. But look at what this passage is saying. We're saying these covered government entities, those jurisdictions that receive assistance, essentially cannot have a nuisance ordinance that includes a definition of nuisance that penalizes people for requesting or accessing emergency services. So that's great. So this, on its face, it seems as though the VAWA Reauthorization Act of 2022 is starting to address that prevalence of problematic nuisance ordinances that both Marcos and I walked through when we showed those numbers. So I think it's important that we all keep our eyes open and see what the department does say about this as people have had the chance to read through and digest. But just to put this out there, this is in the Reauthorization Act. And I believe that is my next slide. My last slide. Yep. There's my contact info. I love talking. I love getting questions. So if people have questions outside of this event, please feel free to preferably email me, since we're still not back in the office that often. But I appreciate everyone's time today. Hopefully next year we'll be doing this together in person, but thank you for your patience. Thank you for your attention, and have a wonderful day.
Thank you so much, Nathaniel, and to Marcos. I think we should take a few minutes right now to pause for any Q&A for the speakers. Please feel free to type your question into the Q&A box. Okay, looks like there's a question from a participant. Do you know if HUD or other advocates for fair housing are working on getting rid of crime-free laws?
I can answer that,
Sure.
at least from our perspective. So yeah, we NHLP is working with a bunch of organizations and advocates in California to pass a bill that doesn't outright prohibit or preempt local crime-free programs and nuisance ordinances, but it sort of attacks the specific aspects of these laws so that effectively it would eliminate these laws in the state at least. And so initially we were planning on introducing that bill this year, but now our plan is to introduce that bill in 2023. If anybody's interested in, learning more or maybe joining the coalition or whatever the case might be, I think my contact information is somewhere in the materials for this presentation. Yeah, just give me a shout out.
I can't speak to any concerted effort on the department's behalf, but I know that this issue is one that is sort of on the assistant secretary's desk because of this administration's focus on racial equity. And we can see the pernicious effect that ordinances like this can have on sort of perpetuating a lot of the problematic patterns that we see. And so the department does have these new ordinances, in front of everyone's eyes, and it is something that we're looking at, though, we don't currently have, at least I haven't been clued into any sort of more concerted effort other than the guidance documents that we've released over the last few years.
Thank you so much. Okay, I think we'll move to the next slides. We'll do some hypos, and then if that jogs further questions, you can feel free to put those in the Q&A as we proceed. So the first hypo is Aria is applying to rent an apartment, and the housing provider runs a criminal background check. The landlord denies Aria's application because he sees she was arrested last year for vandalism. She was never charged, and that she has a 15-year-old conviction for theft. When Aria asks why she was denied, he tells her he found out about her arrest and that he has a policy of never accepting anyone who is a quote-unquote thief. Next slide, please. Can the housing provider consider the arrest for vandalism? And can the housing provider refuse to rent to anyone with a conviction for theft? So enter your response in the poll, please. Okay, just gonna give you one more minute. Looks like about half of the attendees have answered. Okay, last chance to enter your response. Okay, let's see what you said. So can the housing provider consider the arrest for vandalism? 65% of you said no, 29% said yes, 6% said maybe. And the second question, can the housing provider refuse to rent to anyone with a conviction for theft? 41% said yes, 12% said no, 47% said maybe. So need some work here. Let's explain on the next slides. Next slide, please. So these were the correct answers. So most of you got the first one right, that the arrest didn't lead, the answer was no, the housing provider cannot consider the arrest for vandalism, and that's because it didn't lead to a conviction. So this is under our state fair housing regulations under the FEHA. And can the housing provider refuse to rent to anyone with a conviction for theft? And the correct answer was actually no. And this is because this is a blanket ban, and housing providers have to evaluate things on a case-by-case basis. So we will distribute the slides. This was addressed earlier. So take a look at those. Moving forward. Next slide, please. And, wait, hold on. There's something wrong with this. You can go ahead and okay. Can the housing provider refuse to rent to Aria because of the theft conviction? Little longer to enter your response. Okay, last chance. You want to enter an answer? Okay, great. So looks like 24% said yes, 38% said no, and 38% said maybe. So the correct answer was maybe, but probably not, but still maybe. And the reason is because the housing provider has to show that it's necessary to achieve a substantial, legitimate and non-discriminatory interest, and that it assists in protecting resident safety and or property. So since the hypo said that it was a 15-year-old conviction with no subsequent convictions, it's probably not very predictive of the future behavior of the tenant. So she should be allowed to submit mitigating information, and it probably shouldn't be a grounds for refusing to rent. So it looks like the majority of folks said either no or maybe. So great job. Next slide, please. Liam lives in an apartment in Pawnee, California. He has a mental health condition that causes him to become very depressed. One afternoon, he threatens to harm himself. His family is worried for his safety, so they call 911, and the police, fire department, and an ambulance come, and they take him to the hospital. The family called emergency services 6 months ago for the same reason. A week later, the family receives an eviction notice. The notice explains that they have violated the city's nuisance ordinance, which prohibits more than one call to emergency services each year. Is this eviction lawful? Next slide, please. So the answer is that eviction is probably not lawful because here Liam is a person with a disability. People with disabilities are more likely to rely on emergency services compared with people who are not disabled. And the ordinance would likely have disparate impact on people with disabilities, which violates the Fair Employment and Housing Act by having that type of policy. And it would also violate another law, which is California's Right to Safe Home Act, which protects people's rights to call for police and emergency assistance, and provides a defense to an eviction in the event that a policy penalizes someone for calls for assistance. Next slide, please. So just in our last few minutes, a few more words on DFEH enforcement. These are a few other activities that DFEH may complete to enforce fair housing rights. There is an administrative complaint process that aggrieved parties can use to file a housing complaint and receive access to an investigation and a mediation. And in addition, DFEH can file court enforcement actions in civil court to enforce fair housing law, state fair housing laws. DFEH is also standing up a fair housing testing program and has a discriminatory ads project where people can report housing advertisements that are discriminatory in nature. Next slide, please. Here's some links and to some of the resources you heard about. DFH has a fact sheet on fair housing and criminal history, link here. In order to find the fair employment and housing regulations on criminal history and housing, they're at 2 CCR 12264 through 12271. So you can read about regarding how criminal history may be used for tenants. That's the link for reporting mandatory housing ads to DFEH. Next slide, please. And these are the links to the HUD guidance on criminal records and nuisance and crime-free ordinances, as well as an NHLP resource. With that, we'll see if there's any final questions in the last few minutes. So it looks like there's another question from Sonia. How does the California Right to a Safe Home Act work with crime-free ordinances? Would any of our panelists like to?
I'll have to defer to Marcos on that, since it sounds like a state law that I'm unfamiliar with.
Yeah, I mean, basically, I mean, to the extent there's a policy or law that limits, prohibits emergency calls, and landlords attempt to use that as a basis for an eviction, you have this law that would serve as a defense to that eviction. I will say, I mean, even though there's this protection, you know, I defended evictions for a lot of years, and just going through that process, the trauma, sometimes even if individuals have a defense, they get into some sort of settlement agreement to move out, despite the fact that they, should remain in their house. So it's a protection. But if there's an eviction that's initiated as a result of one of these local laws or policies, it can still have very devastating effects to the tenant.
Thanks so much, Marcos. And I think maybe one other point to add about the interaction between the Right to the Safe Home Act and crime-free ordinances are that nuisance and crime-free ordinances that penalize calls to the police or emergency assistance are just a subset of nuisance and crime-free housing ordinances. There are many other provisions and features of those ordinances, and some of those ordinances don't actually penalize calls to the police or emergency assistance, but they might have other forms of disparate impact or otherwise violate fair housing laws, as the speakers covered earlier. Any other questions? Okay, I think with that, we can end a few minutes early. Want to thank so much our speakers, Marcos and Nathaniel, and thank all of our participants for joining us today.
Thank you, everyone.
Thanks, everyone. Thanks, Mario. Thanks, Nathaniel.